Welcome to our webinar, Pennsylvania's Business Laws Are Changing. Are you prepared? My name is Anu Shah and I will be your moderator. Joining us today is William H. Clark, Jr. Bill is a partner in the Corporate and Securities Practice Group of Drinker Biddle and Reed LLP. He serves as the draftsman for the Pennsylvania Bar Association and is the author of the 1988 Pennsylvania Business Corporation Law, the Pennsylvania Revised Uniform Limited Partnership Act, and Pennsylvania's Limited Liability Company Law of 1994. Along with his work in Pennsylvania, Bill has drafted corporate laws for North Dakota, California, Hawaii, Maryland, New Jersey, New York, Vermont, and Virginia. And with that, let's welcome Bill.
Thank you, Anu. Good afternoon, everyone. Thank you for joining us. We hope that you will find this presentation interesting and useful. Many of you are not from Pennsylvania, but I hope that at points in the discussion you will learn and hear things that you will find interesting even within your own situations and contexts, because much of what is happening in Pennsylvania at the moment is part of much larger national trends. And so what you're going to hear about today in Pennsylvania will be relevant for many of you in other states as well. On July 1st of this year, in less than 2 months, new provisions of the Pennsylvania entity laws that are found in the Pennsylvania Collection of Entity Laws and Title 15 of the Pennsylvania Consolidated Statutes are going to take effect. Those new provisions fall into 2 categories. There are, first of all, provisions that parallel similar provisions found in the Uniform Business Organizations Code. Those provisions include amendments to Chapter 1 of Title 15, the Pennsylvania Business Entity Laws, which deal with filing to the Department of State. An entirely new Chapter 2 dealing with names of entities will take effect, and a new Chapter 4 dealing with the registration of foreign entities to do business in Pennsylvania will also take effect. In addition to those provisions that are patterned after provisions of the Uniform Business Organizations Code, an entirely new chapter is being added to the Pennsylvania Entity Laws, which is based on the Model Entity Transactions Act, and it completely rewrites the statutory provisions in Pennsylvania that apply to all forms of business entities with respect to 5 different types of transactions. Those transactions are mergers, interest exchanges, that's a new term, but it's a transaction that is a successor to what used to be called a share exchange, conversions, divisions, and domestications. And I will briefly describe for you each of those transactions and some of the significant aspects of each transaction. Before we go any further, however, I want to repeat the comment that I made at the very beginning as we considered this first slide. These are changes that are not yet the law in Pennsylvania. What we're talking about today will be the law on July 1st, but is not yet today in effect. A second comment that it's important to make right now at the beginning of this discussion is that I will not be considering the tax aspects of any of these changes. Any of you that have experience with these types of transactions know that the manner in which they are taxed, both at the state and federal level, is very important and a significant issue that has to be considered. We're not going to talk about that at all today. Our focus is simply on the changes to the entity laws in Pennsylvania that govern these types of transactions. The purposes of these changes that will take effect on July 1st are, first of all, to improve the integration of the Pennsylvania entity laws into a more coherent code so that they represent a single body of law that's well-crafted and relates to the various parts of the law in a way that provides a consistent whole. And then secondly, the other purpose of these changes is to provide a complete set of provisions that authorize these types of fundamental transactions that involve more than one type of entity. Those two categories of changes are the way the presentation this afternoon is going to be organized. We'll first talk about the change in the structure of Title 15 and how it's been integrated into a single code, and then we'll take up a description of these various types of fundamental transactions. So first of all, how the Pennsylvania entity laws are now being integrated into a more coherent code. The picture that you see on your screen has been chosen because it's an easy way of thinking about the structure that we're aiming for in this new Pennsylvania code. It's what we call a hub and spoke arrangement. So think of a wagon wheel with the hub that keeps the wheel on the axle and then the spokes that come out of the hub. That structure is already being used to a certain extent in Pennsylvania law. Since 1988, we have had all of our business entity laws organized in a single code, but the structure since 1988 has been for the hub provisions to constitute a very limited set of statutes which only deal with filings in the Pennsylvania Department of State. So today, even prior to July 1st, the rules for making filings in the Department of State are found in Chapter 1 of Title 15, and those provisions apply to all of the forms of business entity authorized under Pennsylvania law. This is a contrast to the law in Delaware, if any of you are familiar with the way Delaware has organized its statutes. Delaware has not integrated its entity laws into a single code, so provisions relating to filings with the Delaware Secretary of State are found in each entity law, and those provisions on filings with the Secretary of State repeat in each of the entity laws. That's not the case in Pennsylvania. Here we have them centralized in this one chapter. And what is happening on July 1st is that the hub set of provisions in Pennsylvania are expanding to include additional subjects. And so what will be the case after July 1st is that in addition to Chapter 1, which will deal with the actual mechanics of making filings with the Secretary of State, there will be 3 new chapters that we will be thinking of as now part of the hub. Those will be Chapter 2, dealing with names, Chapter 3, dealing with entity transactions, and Chapter 4, dealing with foreign entities. And those chapters will provide one single set of rules that will apply to each of the Pennsylvania entity laws that will come out of that hub as one of the spokes. So you see in the diagram on your screen that the nonprofit corporation law is one of the spokes, the business corporation law is one of the spokes, the LLC statute is one of the spokes, etc. And whenever Pennsylvania lawyers are dealing with one of those types of entities, but they have a question regarding its permissible name or how to register that type of entity to do business in Pennsylvania, they will no longer go to the individual entity law, but instead they will go to the hub provisions. So what this means is that come July 1st, if you have an issue regarding what the permissible name of a business entity is in Pennsylvania, you will go to Chapter 2 of Title 15 of the Pennsylvania Consolidated Statutes. In the past, if you were dealing with a business corporation, you would have gone to Chapter 13 of Title 15, where in Section 1303, there are rules on what constitutes a permissible name of a business corporation. That section has been repealed and is being replaced by Chapter 2. Similarly, if you have a question about what is a permissible name for a limited liability company, instead of going to Chapter 89, which is what you would do today, you will again go to Chapter 2, and you will find there a single set of provisions that apply to every form of entity that can be organized in Pennsylvania. As is the case with names, You will do the same thing with respect to registering a foreign entity to do business in Pennsylvania. Beginning on July 1st, there will be one set of provisions which will be found in Chapter 4 of Title 15, and they will have one set of rules that will apply to registering any form of business in Pennsylvania. So essentially what's happening is that a lot of provisions that previously were sprinkled throughout the various Pennsylvania entity laws are being taken out of those laws and consolidated into one place in the Pennsylvania statutes. And those provisions now will apply across the board to every form of entity. One of the important implications of this rearrangement is that legal principles governing names and registration to do business that are now found in these single chapters will apply to multiple forms of entity. That means that case law that is previously developed with respect to a particular entity, for example, when a corporation is required to register as a foreign corporation, will now be applicable across the board to every form of entity because we now will have one single set of provisions dealing with these issues. That will mean in the future that questions as to when an LLC, for example, is required to do business in Pennsylvania will be determined under the new provision of Chapter 4, and all of the case law that is built up under not only the business corporation law, but all of the other Pennsylvania entity laws will now apply and be applicable to that question and to the interpretation of Chapter 4. So we think that this is going to substantially improve Pennsylvania law and its integration into a single code. We have to recognize, of course, that there will be a bit of a period of adjustment as people continue to go to the individual entity laws, to provisions that they're familiar with from the past, and not find them there. Hopefully, when they go looking for a provision and realize that it's been repealed, everyone will know that you can now go to the hub and you should be able to find the provisions that you're looking for. Before I talk specifically about any of the other changes that have been made and will take effect on July 1st, there's one important introductory comment with respect to terminology that it's very important to keep straight and to understand. The way Title 15 is constructed now, the statute is very careful in its usage of terms that relate to what the statute applies to. And in particular, when you use the Pennsylvania entity laws, it will be important to observe the distinction between the term entity and the term association. Beginning July 1st, the definition sections of the statute will make very clear that there's a difference between an entity and an association. An entity will be defined as one of the types of legal persons or organizations whose governing statute is found in Title 15. So that means, for example, that a business corporation, a limited liability company, a nonprofit corporation, etc., will all be forms of entities. In contrast to that term, the term association is used in Title 15 in a broader sense that includes any type of private organization, whether domestic or foreign, and whether or not organized pursuant to a statute that's found in Title 15. So in effect, if you look at the Venn diagram that you see on your screen, the term entity is a subset of the term association, and it's very important to keep that distinction in mind. The principal reason for this differing use in terminology is the fact that under Pennsylvania law, banking institutions are associations, but they are not entities, because banking institutions, a bank and trust company, a trust company, those forms of organization are incorporated under the banking code and not under a law that's found in Title 15. So banks constitute associations, but they are not entities. This is a particularly important point for any of you that may be dealing with a bank in Pennsylvania, because a very important change in Pennsylvania law occurred in 2012 when limited liability companies were given the authority to have banking powers for the first time. So now we're in a situation where a financial institution can be either an association incorporated under the banking code or a limited liability company and an entity subject to Title 15. And so we've tried to be very careful in the construction of the statute to make that distinction clear. Now, one other very important point for anyone that wants to or will be using the Pennsylvania statutes in the future is to learn a new vocabulary. This is probably the aspect of the changes that take effect on July 1st that will require the most adjustment and getting used to. There is an entirely new set of terms that have been created and defined in Title 15 and Section 102, which are used throughout the statute now. And the reason why this new set of terms had to be created is because once we're putting in place statutory provisions that apply to multiple forms of entities, we need words that help us describe concepts that are common to various entity forms, but that are referred to in differing ways in various entity laws. So, for example, there is a new term, governor, which is defined as a person by or under whose authority the powers of an association are exercised and under whose direction the activities and affairs of the association are managed pursuant to the organic law and organic rules of the association. If you're familiar with corporate law, you'll recognize the middle of that definition, which speaks about the powers of an association and the direction of the activities and affairs of the association, as language that's typically used to describe the directors of a business corporation. And in fact, the term governor is used to include directors of a business corporation, managers of an LLC, general partners of a limited partnership, trustees of a business trust, etc. So it's a new term that is intended to encompass all of the ways that we used to refer to people in similar positions in various forms of entities. Governor was chosen because we did not want to use a term that was already used in one particular entity law, so we needed something new. And you'll find that that's the case with the rest of the definitions I want to show you briefly now. The next definition to note is the definition of interest. That's defined as a share in a corporation for profit, a membership or share in a corporation not for profit, or a governance interest or a distributional interest. So that would include, for example, shares in a business corporation, a membership interest in an LLC, a partnership interest in a general or limited partnership. It's worth noting that you'll see two terms there at the end of the definition, governance interest and distributional interest. Those are also new terms that are now defined in Pennsylvania law, and they are used as ways of describing aspects of what people own in unincorporated entities. In the case of unincorporated entities, the law defines what is owned in the entity with respect either to the governance rights that attach to that interest or the economic rights that a person may own. And so the governance interest refers to the right to participate in the affairs of the entity, and the distributional interest is actually the economic interest. When you put them together, you get a partnership interest or a membership interest in an LLC, but they can be bifurcated, and this is kind of beyond our topic today, but there are rules on what happens if an owner of an LLC or a partnership attempts to transfer their ownership interest in the entity without the consent of the other members, and essentially the law is that you can transfer economics but not governance. And so that's the reason why this definition is created the way it is. Now, it follows then that if what is owned or held as an interest, the person that owns or holds it is the interest holder. And so that term is defined as a direct or record holder of an interest, again, shareholder of a business corporation, member of an LLC. The next two terms, you'll notice, begin with the word organic. And that's a tip-off that they go to the heart of the entity and what's involved in its existence and operation. First of all, the term organic law refers to the law of the jurisdiction of formation of an association that governs its internal affairs. And so that would include, in Pennsylvania, our business corporation law and our limited liability company act, the Uniform Partnership Act, similar statutes. The term organic rules refers to the public organic record and the private organic rules of an association. So those are the articles and bylaws of a business corporation. Let me actually take you to the definitions of those two terms that are part of the organic rules. First of all, the private organic rules. These are the rules that govern the internal affairs of an association, are binding on all of its interest holders, and are not part of its public organic record, if any. So the private organic rules include bylaws of a business corporation, the operating agreement of an LLC, partnership agreement of a general or limited partnership. The term would also include a shareholders agreement in a business corporation if all of the shareholders are bound by the agreement, because you'll notice that part of the definition of private organic rules are the arrangements that are binding on all of the interest holders and are not part of what's been filed publicly for the entity. And then there is, of course, a defined term for what is filed publicly, and that's the public organic record, which is defined as the document, the public filing of which by the Department of State here in Pennsylvania or a similar agency in another jurisdiction is required to form an association. So that would be the articles of a corporation, the certificate of formation of an LLC, certificate of limited partnership, etc. Those are the terms that are now used wherever in the Pennsylvania entity laws we need to refer to the general concept and need to include more than one form of entity. So if there's a provision of the Pennsylvania statutes that only applies to business corporations, then we can refer to the Articles of Incorporation. But if the provision of the statute has a scope that is wider than just business corporations, then we use the term public organic record. All of this may strike those of you who come from states that haven't seen this terminology somewhat strange. It may, in fact, be coming to your state at some point. Remember where we began at the very beginning. These are provisions that we have taken from the Uniform Business Organizations Code that has been prepared by the Uniform Law Commission. Pennsylvania is one of the first three states, actually three jurisdictions in the United States to adopt these provisions. Similar provisions are in place in Idaho, which just passed this statute this year, and also in the District of Columbia, which is why I say jurisdiction, not state. D.C. passed this a few years ago. So at the moment, there are three jurisdictions using this language. The Uniform Business Organizations Code is being considered in other jurisdictions as well, and I think as time goes by, you will be seeing more of this as other states decide to move in this direction. All right, that's the first set of changes that we need to talk about. Now we're going to shift gears and move to the question of entity transactions and the new provisions that are found in Chapter 3 of Title 15. And again, remember, this is not yet the law. It will be on July 1st, and before you use any of these provisions, make sure you talk to a tax lawyer. Okay. So there are 5 types of transactions that are covered by new Chapter 3. Mergers, interest exchanges, conversions, divisions, and domestications. First of all, mergers. We're all familiar with mergers. We now have a set of provisions in Pennsylvania that will provide for any form of entity to merge with any other form of entity. So if you have a corporation and an LLC that want to merge, these provisions will permit the combination of those 2 entities into one. In this case, the illustration is of the LLC merging into the corporation with the corporation surviving. A variation on the merger provisions is what we used to call in Pennsylvania a consolidation. And that's a transaction where you begin with 2 entities, and as a result of the filing in the Department of State, those 2 entities are combined, but not in a manner that one of the entities survives, but rather an entirely new entity is created. So the new provisions of Chapter 3 will permit a corporation and a limited partnership, for example, to merge into a new LLC that is actually created as a result of the filing in the Department of State. And the provisions on mergers provide separate rules for determining when a filing relating to a transaction is effective and when the transaction itself is effective. And those 2 concepts are treated differently. There are rules on when the filing that has been made itself takes effect, and then separate statement as to when the underlying transaction is effective. And so the statute then says that a merger itself is effective when the Pennsylvania filing has taken effect if all the parties to the merger are Pennsylvania entities, or in the case of a more complicated transaction, a merger is effective when the Pennsylvania filing has taken effect and any required filing in any other jurisdiction has also taken effect. The concern being that although we always try to coordinate the effectiveness of filings where we're dealing with multiple jurisdictions, we can't be sure that that will always be the case. And so as a fallback, the statute effectively postpones effectiveness until both of the filings, or all of the filings, if there's even more than one and more than 2 entities, have taken effect. So you first of all look to the effectiveness of the filing itself. If it's a transaction that only implicates a filing in Pennsylvania, then the transaction itself takes effect when the filing takes effect. But if more than one state is involved, you have to look to the effective date and time of both of the filings. One interesting point in Pennsylvania that contrasts, I think, pretty sharply with Delaware relates to the question of what happens to contracts in a merger. And Pennsylvania law provides that when a merger takes effect, contracts to which any party to the merger is a party. So if a party that's merging is a party to a contract, the law provides that the contract vests in the successor without assignment. And that's a contrast to the law in Delaware, which distinguishes between what are called forward and reverse triangular mergers. In Delaware, contracts are considered actually assigned by operation of law in the case of a forward triangular merger, but not a reverse triangular merger. And so you see on the screen diagrams of those 2 types of transactions. You have the acquiring company marked as the buyer. It sets up a subsidiary to do the transaction, and then the target either merges into the new subsidiary that was set up, or the new subsidiary merges into the target. And where the target disappears, Delaware says that contracts to which the target are a party are considered to have been assigned. That's very important in the context of planning the transaction, because if you're going to do a forward triangular merger, that means you have to be careful and diligent to identify any contracts that will be considered assigned to make sure that they do not have anti-assignment clauses in them that would be a problem. On the other hand, in a reverse triangular merger structure, that's not an issue, and anti-assignment clauses would not be triggered. And again, there are important tax ramifications to the distinction between forward and reverse, but we're not going to talk about them today. I want to continue, however, with this theme that we've just started on of triangular mergers and move to a transaction that we call an interest exchange. Essentially, an interest exchange is an alternative way of doing that triangular merger that I just showed you. Today in Pennsylvania, a form of transaction like an interest exchange is authorized for business corporations, and it's called a share exchange, but it's not available with respect to any other form of entity. But once we get to July 1st, it will be possible for any type of entity to engage in an interest exchange. So what's going on in an interest exchange? Well, it's a triangular merger where you don't need to set up the third party to the transaction, and so it's no longer a triangle. Here's the typical triangular merger structure. This, again, is what we saw 2 slides ago, where the buyer has a deal to acquire the target in a merger between the target and a deal sub. When that merger occurs, effectively the buyer ends up owning the target, and the former owners of the target receive in the merger to which the target is a party, typically either cash or interest in the buyer, or they can receive other forms of securities or other consideration. So you effectively end up with a picture on the screen where the buyer owns the target, which is exactly the result now that we're going to be after in an interest exchange, but as you'll see from the following diagrams, without the third entity. So at the beginning of an interest exchange, what you have is the buyer contracting directly with the target to do an interest exchange. You'll notice there's only 2 entities now in this diagram. What happens is that the target approves the transaction as required under Chapter 3, and it then makes a filing with the Department of State, and as a result of the filing, the interest held by the target's interest holders are exchanged for the agreed consideration in the deal, and what you end up with is the structure you now see on the screen. You'll notice that that's exactly the same result that you get had you done a triangular merger, but in this instance, you've now been able to do it without setting up the new subsidiary corporation, and so there's not been a triangle in any of the diagrams that I've just shown you. Now here's a more interesting example of what can happen in an interest exchange. Assume now that the buyer wants to acquire a target entity that has 2 classes of interest holders. So it has interest holders owning Class A interest and also interest holders owning Class B interest. In this case, the buyer is willing to leave the Class B interest holders in place, but wants to acquire the interest held by the A holders. And so it signs a contract to do an interest exchange. The target goes through the necessary approval mechanisms, and then a filing is made with the Department of State. And what you end up with is a situation in which the buyer exchanges the agreed consideration for all of the A interest, and the buyer now owns all of the A interest, but nothing has happened to the B interest holders, and they continue to hold all the B interest, and the A interest have now been cashed out or received whatever other agreed consideration had been provided for in the terms of the transaction. The next type of transaction we need to talk about very briefly is a conversion. This is a major change and improvement in Pennsylvania law because today direct conversions of an entity into another form of entity are not authorized in Pennsylvania law. Today, if you want to convert an entity into another form of entity, you have to set up a wholly owned subsidiary that is the new form of entity and then merge the existing business into the newly formed entity. Under the new provisions, you will simply by making a filing in the Department of State directly convert, simply by virtue of that filing, your existing entity into another form of entity. In what I've described for you on the screen at the moment, it's a transaction where both before and after the conversion, the entity is subject to Pennsylvania law. It's also possible to do a conversion going across state borders if both states authorize the conversion. So if you had a corporation in Arizona, by doing a conversion transaction, you could directly convert it into a limited liability company organized under Pennsylvania law. So what you have there is both a change in the form of the entity and also a change in its jurisdiction of formation or where it's domiciled. So two variations on the form of a conversion. And of course, as part of this second type of conversion, what you're doing is switching jurisdictions of formation, and you can do that without needing to change the form of the entity. So under Chapter 3, there will be a new form of transaction called a domestication, in which a corporation in one state, simply by making appropriate filings, can switch to become a domestic corporation in another state. What you have on your screen at the moment is a picture of an Arizona corporation converting to a Pennsylvania corporation. But notice that Pennsylvania law says expressly that Pennsylvania does not require the domesticating entity to give up its status as a domestic entity in the jurisdiction in which it starts. That's another kind of long-winded, complicating way of saying that you could take an Arizona corporation, use the domestication provisions to move to Pennsylvania, but not make a filing in Arizona to terminate the existence under Arizona law. And what you would have is what we refer to as a dually incorporated entity, because following the domestication, in this case, Corporation A would be subject to both the Arizona and the Pennsylvania domestic corporation provisions. Those types of transactions are sometimes done for tax reasons. You don't see them very often, and obviously, as you might imagine, it's a fairly complicated place to end up, because after this type of a domestication, the corporation would have to comply with both the Arizona and the Pennsylvania corporation laws to the extent it could. And I think most people believe that if there's a conflict, you have to comply with the most restrictive or maybe best described as an onerous provision of each of the two states' laws. Now, at this point, I want to move to what I think people from states outside of Pennsylvania will find quite interesting, if not mind-boggling, and something that gives you a headache because you may not have ever heard of this before. But there is, under Pennsylvania law, a form of transaction called a division, which is unique to Pennsylvania and Arizona, believe it or not, and is similar to a transaction in Texas, but does not exist anywhere else in the United States, to the best of my knowledge. Pennsylvania has permitted divisions of nonprofit corporations since 1972 and of business corporations since 1988. We've also had them for LLCs and other forms of entity. Arizona just recently adopted essentially the same set of provisions dealing with entity transactions that I've been describing to you today. Arizona adopted a version of the Model Entity Transactions Act, just as has occurred in Pennsylvania. And Arizona adopted the Pennsylvania division provisions. So we now have two states that have exactly what I'm about to describe for you. And Texas, for a number of years, had has had a transaction called a divisive merger, which is not quite a division, but allows you to do very much the same thing, but through a transaction that continues to be referred to as a merger. So what happens in a division? Well, you start with a corporation, and it has, in an unincorporated division, assets and liabilities, which it wants to put into a separate entity. So you'll see in this diagram, the corporate box is divided by a dotted line as a way of showing that there's a set of assets that we refer to as B that are off to one side that the corporation wants to split off into another corporation. And what it does is to approve a plan of division, make a filing with the Pennsylvania Department of State, which is required to describe how the assets and liabilities of the corporation are to be allocated between the existing corporation and the new corporation. It makes a filing with the Department of State, and the result of that filing is to result in the corporation itself surviving, but Corporation B begins its existence with the assets and liabilities specified as having been allocated to it in the filing with the Department of State. And so you have now two corporations where there was previously one. One way to think about this is simply as the reverse of a merger. Because if I took the diagram on your screen and simply reversed the direction of the arrow, you would have a classic picture of a merger where Corporation A and Corporation B merge together with A as the survivor. In the division, we're simply doing the reverse and taking apart Corporation A. Now that Arizona has passed divisions and they're in Arizona law, we can take the prior picture and instead of dividing just into two Pennsylvania corporations, we can actually place the B assets and liabilities into a new corporation that exists under the law of Arizona. This would take two filings, one in Pennsylvania and one in Arizona, but when those filings became effective and the transaction became effective under both Arizona and Pennsylvania law, you would again have done the reverse of a merger. So again, if the arrow were running the opposite direction, you could take the Arizona corporation and merge it into the Pennsylvania corporation. We've always been able to do that kind of transaction. So again, this is the reverse of what's going on there. Now, another way to do a division is essentially the reverse of a consolidation. Remember, in a consolidation, we take two entities, and by virtue of the filing of the Department of State, they are combined, but the survivor is a brand new entity that's created in that consolidation. Here, posit that we have a corporation that has assets that, just for clarity, I'll refer to as the B assets and the C assets together that make up Corporation A. You can do a division to place the B assets in a new Corporation B and the C assets into a new Corporation C. Again, if the arrow went the opposite direction, that would be a classic picture of a consolidation. And of course, if you can do that just in Pennsylvania, now you can do a transaction in which you take a Pennsylvania corporation and you divide it into a Pennsylvania corporation and an Arizona corporation, both of which are new and have placed in them the assets and liabilities that were allocated to them under the plan. Now, life gets even more interesting now that we have this consolidated set of provisions that includes all forms of entities, and some of you can probably imagine what's coming next. Let's, by way of example, start with a corporation where, again, there's a set of assets and liabilities that we'll refer to as B, and now, instead of doing a division in which we create a second corporation, we can instead do a division in which we create a new LLC to hold the B assets. Similarly, we can do that same transaction, but there's no need to necessarily put the LLC in Pennsylvania. We can take our Pennsylvania Corporation A and divide it into itself, the existing Pennsylvania Corporation A, and now a new LLC, but in this case we'll put the LLC in Arizona, again, because both states now permit this kind of transaction. Or if we think about the consolidation example, where the corporation that's dividing, or the entity that's dividing, because although I've used a corporation in all of these examples, you can start with any form of entity. Now what we can do is take an existing Pennsylvania entity and in a division divide it into different forms of entities. So we take our corporation A with the B and C assets and liabilities and divide it into a new limited partnership and a new limited liability company. Notice now no corporation present at all following the end of the transaction. And of course, you might guess what's coming next. We can also do that transaction and place one or more of the resulting entities in a different state. So now, just arbitrarily for purposes of illustration, we take our Pennsylvania corporation, divide it into a Pennsylvania limited partnership and an Arizona LLC. Now, obviously, the sensitive part of this transaction is the movement of assets and liabilities from the one corporation into a new entity. And so there are very significant rules, which will be found in new Section 368 of Title 15, on when an allocation of liabilities will be respected. And as long as you satisfy the test in the statute, as a matter of Pennsylvania law, the allocation of assets and liabilities will be respected. If the allocation is not respected, then all of the resulting associations, everything that exists after the division, will be jointly and severally liable. So if you violate these tests, even though you do the division and you have two or more entities following the division, the consequence of violating the test is not to unwind the division, but rather to make all of the entities that exist after the division jointly and severally liable for the obligation, the liability that was not properly moved. And the test for allocating those liabilities is twofold. First of all, the allocation of liability cannot breach an obligation of the dividing association. So if, for example, there were a contract that says it's a breach of this contract for the party to the contract to engage in a division, obviously that would be a breach of the contract. And in that case, all of the resulting entities would be jointly and severally liable. And secondly, there's a complicated set of provisions that effectively has the result of saying that the allocation cannot constitute a fraudulent transfer. And to accomplish that result, the statute defines in terms of fraudulent transfer law the role of the various entities and what's going on and how you measure the permissiveness of the transaction. However, if you satisfy those tests as a matter of Pennsylvania law, the allocation will be respected. It's worth noting as well that the tests for distributions, when you can pay a dividend, for example, from a business corporation or make a distribution from an LLC, do not apply to the allocation of assets and liabilities in a division. Now, one of the things that people, I'm sure, from states other than Pennsylvania are probably asking themselves at this point is whether the division statute that's now in Pennsylvania and Arizona actually works and whether there have been any divisions conducted under these statutes. And the answer is that yes, there actually have been lawsuits and the division statute has been partially tested. The most notable division that's occurred under the Pennsylvania statute occurred 10 or 15 years ago and involved the insurance company Cigna, where Cigna divided itself into two insurance companies, one that had as its purpose holding the assets and liabilities, essentially the business that Cigna wanted to exit from, and so they put their runoff business into one company, and then they put the insurance business that they wanted to continue to engage in another company. And that transaction was actually challenged in lawsuits in Pennsylvania, and the Pennsylvania Supreme Court investigated and evaluated the process by which the division had been approved by the Pennsylvania Insurance Department and validated that process and upheld the division. There's also been a division of a publicly traded company in Pennsylvania, which was PPL Corporation, which is the new name for the old Pennsylvania Power and Light Company, and they were a party to a statutory division. And in addition, we've had, over the years, quite a few divisions of nonprofit corporations, because this type of transaction first came into Pennsylvania law with respect to nonprofit corporations way back in 1972. And whenever a nonprofit corporation that holds charitable assets divides, it needs to get court approval to make sure that the assets are not being diverted from their charitable purpose. And so there are at least a dozen opinions of trial courts in Pennsylvania evaluating divisions of nonprofit corporations. Now, a few final comments about the procedures for approving these types of transactions. What happened basically in this whole new set of statutory provisions is that we were reorganizing and rationalizing the statutory provisions on all these subjects, but there were not major substantive changes in the law that have been made that will take effect on July 1st. All of the existing approval requirements with respect to mergers and other transactions essentially are remaining unchanged come July 1st. So the rights of shareholders to vote on a merger remain unchanged, or on a division. Conversions are new, but the same approval requirements as applied to mergers are being applied to conversions. So not significant substantive change in the rights of owners of entities. Dissenters' rights will essentially continue unchanged for shareholders of business corporations with respect to mergers, interest exchanges, which used to be called share exchanges, and divisions. Since a conversion is a new type of transaction, the provision of dissenters' rights for shareholders in a conversion is new, but is consistent with existing public policy, so no real change there. The one place where there is significant change in the law is a new approval requirement in cases where there is interest holder liability that's involved in a transaction. Interest holder liability is personal liability that an interest holder has for either a liability of an association simply as a result of being an interest holder, or an obligation to contribute to the association imposed by the organic rules. What does that mean? The first example is most obviously the case of a general partner in a general partnership. If you are a general partner in a general partnership, you are personally liable for all of the debts and obligations of the partnership. The second example typically arises in the case of unincorporated associations that impose mandatory requirements to contribute to the capital of the entity. So if you have an LLC that has a mandatory capital contribution provision in its operating agreement, anyone who's subject to that has what we call interest holder liability. And the new approval requirement provides that a transaction must be approved, meaning a merger, division, similar transaction, by any person that will have interest holder liability following the transaction. So classic example would be a corporation that merges with a general partnership, and the general partnership is the survivor. If a shareholder of the corporation changes from being a shareholder, where the person is not personally liable for the debts of the corporation, to being a general partner, obviously they've picked up substantial exposure to personal liability potentially, and that should not happen to them without their consent. And so the statute requires that. The more likely example of a transaction involving interest holder liability is probably a situation where a person is becoming subject to a mandatory capital contribution requirement. So, for example, if you have an S corporation that wants to convert to being an LLC, and I use that example consciously because by and large an S corporation can probably convert to being an LLC without substantial tax costs. But if you go from being a shareholder in the corporation into the LLC and the operating agreement of the LLC imposes a mandatory capital contribution requirement, then you would be picking up interest holder liability and your consent to the transaction would be required. All right. That brings us to the end of the discussion. I do think it's worth noting that if you're going to be dealing with Pennsylvania law after July 1st, this is a time when it would be really useful for you to have handy a full copy of the statute. And I say that because I think with the way the statute's been reorganized, it may actually be much easier for you to shuffle through pages of a book rather than try to do this on the internet. We have tried to add cross-references, and depending on the source you use, they will indicate where provisions are repealed. But CSC has a new publication of the Pennsylvania entity laws, which includes the statute as it will take effect on July 1st, and so I encourage you to think about picking up a copy of the statute. So that brings us to the end of the actual prepared discussion. Let's talk about questions and answers. Anu, do we have questions that have come in?
Yes, Bill, quite a bit. So thank you very much for the presentation. It was very helpful. We will now open the Q&A session. Also on the screen, we have two questions for you. CSC has developed a white paper with further discussion and insight on the new provisions in Pennsylvania entity laws found in Title 15, including a Q&A with Bill. To receive your copy of the white paper, please select yes on the screen in front of you. Also, the state of Pennsylvania will amend business entity forms to capture the changes to Pennsylvania's entity laws. To receive notification of changes, please select yes on your screen. You can also contact your CSC customer service representative at 800-927-9800 so they can provide you with a CSC global login where you will have access to over 3,000 of the most up-to-date forms. And also, just as a reminder, you can download a copy of today's materials from the handouts box. Finally, if you'd like to see what other webinars CSC is offering, click on the free education webinars link in the Join Us for More box. Also, you'll find the changes discussed in today's webinar in the 2015 edition of Business Laws Governing Business Entities from CSC Publishing. You'll find a link to purchase the book in the Join Us for More box on your screen, or you can call 800-533-1637 to place your order with a representative. So now, Bill, we'll take some questions from the audience. John asks, is Pennsylvania's Corporation Bureau prepared for the changes?
The answer is yes. They've been working very hard to be ready for July 1st.
Okay, great. So
And in
Phil's
fact,
wondering.
I can actually tell people more specifically. I just did a program on this topic where a lawyer from the Department of State was present, and she explained everything they're doing and assured us that they would be ready.
Perfect. Phil is wondering, how will the changes affect business entity forms in Pennsylvania?
So as part of what the Department of State is doing, they have completely rewritten all of their forms. They have not yet released them in final form, but they're planning to do so before July 1st.
Okay. Meg is asking, what challenges do you expect to see on July 2nd? How can we avoid them?
I think the most likely problem that's going to arise come July 2nd is filings made by people who were not aware that the law had changed on July 1st. The Department of State is ready to process everything that comes in under the new law, but of course that means that the people preparing the filings need to know about the changes and use the new law for their filings come July 2.
Okay, makes sense. Arena's wondering, will other states follow this path in the future?
I believe they definitely will, and certainly the Uniform Law Commission is actively working in various states to promote the adoption of both of these sets of changes, because remember, both the provisions on names and foreign entities in the hub and also the entity transaction provisions come from Uniform Law Commission products. And in fact, someone else had asked again for a list of the states that had already done the hub and spoke, and those are Idaho and the District of Columbia in addition to Pennsylvania.
Perfect, thank you. Tara's wondering, is it still necessary to file a formal withdrawal when converting, or will the new conversion forms make the withdrawal process no longer a requirement?
All you will do is file the conversion document, which is called a statement of conversion, and that's all you'll need to do.
Okay, Bill, so we've gone a little over. That is all the time we have today. If we didn't get to your question, we will contact you with a response after the webinar. Thank you to everyone who joined us today, and Bill, thank you very much for the time that you spent going over all these changes. We hope to see you all next time. Thank you.